I'd like to officially welcome everybody to the very first insurance coverage roundtable that Smiley Smiley is hosting. And we're looking forward to this being the start of a regular series where we have the chance to meet with lawyers from various practice areas to talk about coverage issues that affect all of us. We would like this to be interactive. So if you'd like to keep your camera on, that's great. Please feel free to do so we can see you. If you don't want to, you don't have to. The idea is to take away whatever from this that you'd like. So please feel free to put on your cameras. I'd like to keep everybody muted. If you'd like to speak, just unmute. Again, this will be interactive. So there's a couple of ways you can just talk. You can throw your physical hand up. There's a reactions button on the bottom here of your Zoom screen that will allow you, when you click on it, to raise your hand, and it'll look like this, like my hand is raised. That'll show us that you've got something you want to ask. You can also feel free to type things into the chat. Speaking of the chat, we've already preloaded a few resources in there for you. There's a flow code, which is sort of new technology that we're checking out a little bit. And you can see I have one on my screen, and my flow code's a little different than Rosa's. Rosa's flow code is not up on her backdrop yet, so we put it in the chat. You can literally hold your camera up to these codes and with your phone, and it'll take you to a flow code page, which is direct links to all kinds of services. So on Rosa's flow code, which is in the chat, you'll be able to see all the coverage services that we offer. And on my flow code, all right, so Kyle, the code is this circle. So if you look, you can see it right up on my background. It says scan for more. And if you scroll up in the chat, it should be there. If not, I can re-put it there. If no one sees it, okay. So that's the full code. You just hold your camera up. The one in the chat will have all the stuff regarding our insurance coverage work, specifically Rosa's work, and the one for me will take you to my book, my podcast, my one-on-ones, and all of that. Also, if you want to have a complimentary meeting with Rosa to go over anything or just to chat and catch up, since I know many of you go way back, or talk about any issues you have on any cases regarding coverage, I put that link in the chat as well. You can get to that also through the flow codes. Also, if you have not done a one-on-one with me yet, I think I just recently had my 215th meeting with a lawyer over the last couple of years, which I really enjoy doing. And you can sign up at my flow code or at the Mentor ESQ. So without further delay, I'm going to be pleased to turn this over to Rosa. Rosa Feeney, many of you know, and if you don't know, you're going to get to know her. And Rosa is the chair of our insurance coverage practice, where we represent policyholder clients, and we've really been coming across some really fascinating issues that people are having with their cases, especially a lot of plaintiffs cases, but also defendants defending cases. So we're just happy to pull the community together, have it interactive. For those of you who have just joined, please feel free to turn on your cameras if you'd like, and feel free to ask questions as we go along. And Rosa, I will let you take it from here.
Okay, great. Yeah, so hello, everybody. Thank you for joining. I really appreciate it, and I'm glad that people took the time out today. And like I said, we're going to hopefully be scheduling more of these. They don't have to be an hour. I know we're all very busy. So, they can be shorter ones, or they can be ones that we specifically designed for, like you and your firm. So if you have a firm and you have, a bunch of coverage issues you want to discuss with somebody, feel free to reach out to me. You can do it through my the one-on-one or an email, or just give me a phone call, and we could set up a private roundtable. We've been doing that with some of our clients. And that's kind of helpful sometimes, just if you don't want to discuss something outside the firm, it's just issues that you have. So I want these roundtables to be as interactive as possible. I want you to bring, your questions, your concerns, your ideas, your answers. I mean, I know from the people that have joined this and people from the list of the people that signed up, we have a lot of seasoned litigators here. So this is a great forum to exchange ideas, exchange, just strategies that we use on these cases. And this is the kind of thing that we want to build. And this is what this roundtable is supposed to be all about. And we're exploring it with our peers. And the great thing about it is that most of us, at least as far as I know, are New York practitioners. So it's really practical information that we're getting, regarding these insurance coverage issues that many of us face. Obviously, that's why you're here, because obviously you have some interest in the insurance coverage, aspect of the law. So, like Andrew said, we're offering the one-on-one. If you just one person and you don't want to do a big round table, you just want to talk to me, reach out on the one-on-one. If you click on that, it gives you my calendar, and then you can schedule it when it's convenient for you. And that way it works out.
If you just joined late, all that information's in the chat. So just scroll into the chat. You could scan on the flow code, the circle there, or you can click on the Calendly one-on-one link in the chat.
So I just want to give you a little bit of background about who I am. For those of you who don't know me, some of you do know me. I've been practicing for more than 30 years. And for the entirety of my career, I represented plaintiffs and defendants in personal injury and property damage cases with a focus on insurance coverage. For most of my career, I handled policyholder work and carrier work. And that is what I did for the majority of my career. But slowly, over the last probably 10, 15 years, I started to do more policyholder work, so insured work. And I really enjoy that work. These people really have a stake in the situation. Sometimes these people don't even know what they have in their policies, what's covered, what's not covered. They get caught off guard when there's litigation and suddenly there's no insurance. And so I found it very compelling, and I really like that type of work. So recently, when I joined Andrew and Smiley, we decided to focus in on the policyholder work and the plaintiff coverage work. And I'll explain that in a minute. So on the policyholder end of things, aside from, DJ actions, as Jack Glansberg, who's in our group there, knows, we have a couple of cases together. But aside from handling the defense of the insured or the prosecution of a DJ action on behalf of the insured, we also do a lot of consultancy with our clients, because I find that, and this kind of developed from getting a case from a client, and the client said, I need help with all future insurance because I don't know what I have. How am I going to be covered in the future? So the consultancy involves, I review, their contracts, their indemnification provisions, their insurance procurement provisions. I review their insurance policies. I review their subcontractors' insurance policies. I review, if it's a landlord, I review their tenants' insurance policies. So it's kind of a really global service that we provide. It's almost like a risk management service, but it's, for companies that don't have the capability of having, a full-time staff, risk managers. So on the policyholder side, that's what we're doing. For those of us who handle plaintiffs' cases, what we do is, I assist the plaintiffs' firms in understanding what's going on with these coverage disclaimers. So in all of these cases, and let's just talk about construction, because that's what we're going to talk about in a few minutes. In all these cases, if there's a bodily injury case, the plaintiff is getting carbon copied on these disclaimers. They get the disclaimers and they have to figure out what to do with this, how to evaluate their case. Is this case worth going forward if I'm not going to have any coverage? How am I going to manipulate or maneuver through this myriad of disclaimers? Because I don't know about you all, but in the construction litigation context, there are a lot of disclaimers. So we've been assisting the plaintiffs' firms in doing that. Now, in New York, as most of you probably know, plaintiffs have very limited rights when it comes to challenging insurance coverage issues, right? They can't just go in and sue a defendant's insurance carrier. There is very limited circumstances where they can do it under the insurance law, but for the most part, as a general rule of thumb, it's very difficult for them to do it. So what I try to do is I try to work with them to figure out how we can get to the correct end result, right? And whether you're a plaintiff or you're a defendant, in a litigation, and I'm not talking about carriers, I'm talking about plaintiffs and defendants, whether you're a plaintiff or defendant, when it comes to insurance coverage, I think we're all pretty much aligned. Everybody wants coverage because at the end of the day, where you have an owner that's going to be liable under the labor law, right? Doesn't have any coverage, they have an asset that needs to be protected. So as a defendant, if you're representing an owner or the GC, you want to protect those assets and you want to push off the risk and transfer the risk off to the sub. And, as a plaintiff, we want recovery for our clients. So in that respect, everybody's aligned in getting coverage. So I think that when it comes to, discussing coverage, I mean, barring, a conflict of interest, that somebody could have, if you represent a carrier, you might have a conflict of interest in discussing certain things, but we don't really have conflicts because we represent policyholders and plaintiffs. I mean, obviously we have to be careful with those entities, but for the most part, we don't really have those conflicts. So we're pretty available to discuss various coverage issues. What I want to do is I just want to start off with what I'm going to call like the anatomy of a labor law coverage case so that we all know where we're coming from. And then I do want to open up the forum to see if people have questions because I don't want to just sit here and talk for an hour or so. We all know these labor law cases. You have the plaintiff, right? And the plaintiff is going to bring in the general contractor and the owner because statutorily there's liability under the certain provisions of the labor law, and we all know them. It's labor law 200, 240, 241-6. And, once you have that statutory liability, the plaintiff basically has to prove that, there's certain violations and that there's statutory liability. They move for summary judgment, and now they have a judgment. And now we're off to the races. And now the defendants all start fighting, right? Who's going to cover what? Who's responsible for what? And these cases, because of all the coverage aspects of it, as you all know, take years to litigate. The coverage parts of these cases have a life of their own, in my opinion. They absolutely consume the cases. So now you have the plaintiff and you have the owner who has a primary policy and should have an excess policy, umbrella. Then you have the GC who's got a primary policy and an umbrella policy. Then you have a subcontractor who's got a primary policy and an umbrella policy, and maybe even more layers than this. And then you have another subcontractor who's got a primary policy and maybe, hopefully, an umbrella policy. Right there, you have 8 different insurance carriers that are trying to navigate through this case. And then on top of that, now you have all the disclaimers and all the reservation of rights that start coming in. And that's what makes these cases so complicated. It's just by nature of the volume of carriers and disclaimers. And in the construction litigation area in particular, the reason why, in my opinion, and if somebody else has another opinion, they can raise it, we have all of these issues are because the way the labor laws are, they impose the liability on the owner and the GC, and the carriers have to mitigate these risks. They know the risk that you're going to be held liable statutorily as an owner of GC. So they want to make sure that their subs or their insureds are getting the right insurance, or that their subs are getting the right insurance, so that everything can get pushed down the ladder. And quite often that doesn't happen. And that's exactly what happens in all these cases. There's these exclusions, which we can talk about, employee exclusions, and there are all these action over exclusions, and there's disclaimers all over the place, and then people end up without coverage. I hear the plaintiffs say all the time, well, there's an asset, so I'm just going to attach the building and attach the asset. And that is true. That is one advantage that the plaintiffs have in the labor law cases. They can attach the asset, but let's face it, who really wants to just attach the asset? That's not what we want. We want to make sure that there's enough coverage so that our client can be compensated for their injury. And as a defendant, you want to make sure that there's enough coverage so that your client is protected, right? So we all kind of have that same goal, with respect to the end game in these cases, in these litigations. So, that being said, I have a couple of, and I want to discuss at some point, a couple of strategies that I use that many of you may know in terms of how to challenge these coverage cases. But I want to open up the floor for people to start asking questions. You came here with questions, I hope, for, concerning construction litigation, and I'd like to start the dialogue. Does anybody want to post something in the chat or just speak up? And
feel free to unmute yourself and just ask away, or throw a hand up through the reaction, or put a question in the chat. And don't be shy. If nobody wants to ask one, I have millions of questions I can always ask, but we're here to help you. So if you have anything going on a current matter, or any consistent problem that you see happening, Stephen, I see you unmuted. Do you have something?
No, I don't have anything. Sorry, I just got out of my car, got home. I hit that button by accident.
All right. So Rosa, okay, Kyle, go ahead, Kyle.
Sure. This might be a kind of general question here. It might be more of indemnification than insurance, really, but there are a lot of cases like where if you're representing a GC or a sub or an owner, and all you have at the time is like the either a certificate of insurance and maybe not even like a full complete contract to try and tender to someone. I guess, and how would you deal with having a limited documentation to base your tender on, nevertheless tendering, and then how to work through those issues as you're kind of trying to assert your rights, as either additional insured and or contractual indemnity.
Right. So, it happens quite often, and you're absolutely right. You get these cases right on your desk, and then you don't even have a contract in these cases. And if you have a certificate of insurance, to me, that's one of the first and most important steps. I, personally always wait for that certificate. And the second I get that certificate and there's an identification of an insurance company, I would recommend issuing a tender. Yes. Do you need the contract ultimately? Yes, of course. And you need the proper indemnification, and you need the proper insurance procurement. But I think it takes so long to get everybody in the game, and carriers and defendants responding in these cases, in these labor law cases, that if you can get your hands on a certificate of insurance, to me, that is the beginning. But you're absolutely right. Like, for example, I don't know if you have somebody in mind, Kyle, that you're saying you represent, whether you're representing an owner or GC or the sub or who it is. But, I find that if you're representing an owner and a GC, I find it's a lot easier. I think that they have these things handy, and they'll get you the contracts, and then you can move from there, depending on how big these companies are. It's when you get to the subcontractor level that things get difficult, in my opinion. And unfortunately, there's no database like in a motor vehicle accident, that you could say, oh, here's the insurance. But I will tell you a strategy that I have used and has been very successful, actually. If you can get your hands on the certificate of insurance, one of the things I think you can do, or you should do, is you can contact the broker on that certificate of insurance, because you'd be surprised how helpful the broker will be, right? So, if you're, let's just say you have a certificate, your insured is whoever it is, an owner or GC, and there's a broker in there. You ask your clients, okay, if I contact the broker, sometimes the brokers have copies of these contracts, and they'll give it to you. Now, if the broker is for one of the subs, right, he might not be as willing to give you a copy of the contract. However, what I have done in the past is I've called the broker, explain the situation, say, look, we have a litigation here. We're going to bring you in. We're going to bring your guy in. So can you, please, pass this information on to your client and let them know that they need to get ready and to get a lawyer, and that we need their insurance information. And that works. I mean, believe it or not, I've gotten information in that exact way where, nobody knew who the carriers were. And suddenly there it is, this broker's cooperating with us. So that would be my suggestion. Does anybody else have a question?
Anyone?
I'm sorry, to do a quick follow-up on that.
Yeah,
Sorry,
of
I'm
course.
gonna
No,
hog the whole.
please.
I'm gonna hog the whole thing.
No.
As a follow-up to that, like, let's say you initially send your tender out with the COI and maybe a contract, and then in the interim, and then you get the kind of standard response, like still under investigation, et cetera. Like, it's not like a real response to your tender. Then the interim, you get like the policy, right? The actual underlying policy where you have additional insured status. Would you like send a supplemental tender letter with, like, right when you get that policy, or would it be something you'd want to like wait until you get a response back from the carrier or the entity to which you're tendering?
No, I would absolutely send something right away. It just, as I said, it takes so long to get everybody to, to cooperate and get up to speed. I mean, I have a case where I sent a tender and it was over a month, and not even an acknowledgement, not even an email saying, yes, I got it. And these cases take so long. I think the more you can do and the faster you can do it, first of all, you're protecting your client. I recently had a case where it was a lot of parties involved. And this case was very, very old, like from 2008, which I don't know about you guys, but I have cases with dates of loss from 2015 still. So this was an old case. So this was even under the old disclaimer rules. That's how old this was. And the defendant, right away, the GC sent a tender to the subs carriers. Now, fast forward to 2008 accident. This is like 8 years later, or whatever, how many years later this is, right? And now the carrier says, we don't have it. We can't find your notice. There's no notice. You never notified us of this, right? So now it was a battle to find that notification. The case had just gone sideways. There were so many different lawyers that had handled this case. So there was different attorneys who'd handle different defendants or what have you. So lo and behold, we find the tender letter, a tender letter in the workers' comp file, actually. And we were able to approach the carrier with that letter and say, hey, you did know about this. And here it is. And they reversed to their position. It was an excess carrier, by the way. And that's why they were claiming that they didn't know about it. So as many times as you can provide them with notice, the better. Provide everybody with notice, primary and excess. Even if you're not sure it's an excess case. I think in the old days, people used to not notify the excess carriers. And maybe it was because the conceptually they thought, well, the level of the injury doesn't exceed the primary layer of coverage, right? I honestly don't think that you can even say that anymore. I mean, the way that these labor law cases have gone and the valuation on these labor law cases is so large that you need all coverage in play. And everybody needs to be put on notice from the beginning. I wouldn't wait. I mean, why are you waiting? Let them say, we're going to close our file. Well, okay, you can close your file, but guess what? You're on notice. So my recommendation is, often and as soon as you can and often put them on notice.
Matt Vopel raises his hand. Go ahead, Matt. How you doing?
Hi, Matt.
Hey, everybody. First off, thank you both so much for doing this. Already been incredibly helpful. I have lots of questions in this area, but I'll start with this one. I have had situations where I'm deposing either a GC or an owner, and they say, yeah, I went to my insurance broker and I told them I'm doing this project at my house. I need coverage for this project. And he gets an insurance policy, and then it's got one of those disclaimers like it doesn't cover any employees at the job site. And so from a plaintiff's perspective, how do you guys handle it? Do you try to get the broker involved in the case? So you have try to get the defendants to sue the broker? Do you try to sue them directly? And then with these employee disclaimers where it says it doesn't cover any employee on the job site, have you had any success in getting around that, or is that just make the policy worthless for this perspective?
Okay, so a couple of things. One is the first part of your question was, how do you handle these situations, right? Where the carrier, they're disclaiming coverage, you're reaching out to the broker. So let me give you an example. And I think this is kind of what you were getting at. So I had a case where I actually got approached by a plaintiff's firm because they had a case where the carrier disclaimed coverage. And again, it's like these employee exclusions, they're all over the place. And they're all different, by the way. I mean, I just saw one 2 days ago I'd never seen before. So they're coming up with all kinds of language and ways to implement the exclusion. And the defendant's not answering the complaint because the carrier disclaimed, right? So, I reviewed it and I believe that there's a way to challenge the disclaimer in that particular case. All right. And I will say, Matt, that those exclusions, for the most part, without speaking about a specific exclusion, because they're all different, but some of those exclusions have been upheld by the courts, right? So it's like it's an uphill battle when you're fighting those employee exclusions. But I had reviewed it and I said, you know what? I think that there's an avenue to fight this. And so what I did was, because the plaintiff can't do anything, the plaintiff doesn't have a right to do anything. So what I did was I contacted the broker and I said to the broker, listen, this is what the situation is. Here's what I think is the defense to this. And I recommend that you contact your client and you tell them that they should get a lawyer because they have a right to this coverage, right? And that has worked. That has worked for me. They don't just hang up on you. I mean, they've listened, which I was surprised at first, to be honest, that they wouldn't be like, oh, who's calling me and why are you calling me? Get away. But they didn't. They listened. They were like, okay. And you know what? I find that brokers are generally very responsible. These are their clients, and they want to protect their clients. So this is something that I think it's a very useful strategy, and it really doesn't, it's basically just saying, please contact. I mean, as I even had a case where the defendant was represented by counsel, right? So now you have a disclaimer. I'm working for a plaintiff, okay? The disclaimer comes in, and the defense counsel's handling the case, and they're like, going to either move to be relieved, or the carrier's going to start a DJ action, right? And so in that particular case, the carrier did start a DJ action. And, I as I said, I contacted the broker. I explained, look, you really should tell your client to get an attorney. And I contacted defense counsel. And I talked to defense counsel, and defense counsel's in a very precarious situation there because they're at the tripartite relationship, right? And they can't be talking about coverage with me at all. And the person didn't. They said, I can't talk coverage. I said, I'm not asking you to talk coverage. I'm just telling you that you need to tell your client about this disclaimer and make sure they understand and know what it is, right? And he realized he had to. That's his obligation, to tell the client, look, you have this disclaimer, you may want to consult a lawyer, right? And that's what he did. And so we got a lawyer on the case, all right? That's the first part of your question. The second part of your question is, how do you challenge these things? So, just like everything else with these disclaimers, like I said, the case law is pretty supportive of those disclaimers, but you really have to look at them, because I just saw one yesterday that I thought, I can't imagine that this could be upheld. It's just the way it was written. But there are other ones that they're just the way they're written. That's the way they're written. Like, for example, I'm sure you've seen the ones where it says that it has to be privity of contract. So in order for your client to be an additional insured, they have to be the one that signed the contract with the sub. Those exclusions are upheld by the courts, and I haven't seen anybody get around those exclusions. So it's really an uphill battle with those. So the only way that I kind of not challenge, but I review and analyze these things is I look at them from the perspective of what is the timeliness of the disclaimer, right? When were they placed on notice, right? So on that case, I gave you the example, the carrier said, we were never placed on notice, late notice, when in fact they were placed on notice. So their disclaimer was late. And that's a pretty strong one. I mean, that is one that, everybody in the biz knows when there's an exclusion to coverage, you need to disclaim. So that's a pretty strong avenue. And that's really one of the main things I look at typically.
Rosa, can you just highlight that that's actually one where if you're representing a plaintiff, you have the right under the insurance law to bring a DJ action.
Right. So if the disclaimer under insurance law 3420, if the disclaimer is based upon late notice, the insurance law, and it's 3420, gives the plaintiff a limited right. See, just to go back, and maybe you all know this, but a plaintiff in New York only has a right to go after a defendant's insurance carrier in most circumstances once they have a judgment that's been unsatisfied for 30 days. And then you can go after the carrier, right? But that's a long haul, to go through a case, and you don't know if at the end of the day there's going to be any recovery, so that's tough, but that's the law. That's the law. So they carved out, I think it was in 2008, 2009, 2008, they carved out an exception to that. And they said, if the basis for the disclaimer is late notice, then we're going to give the plaintiff a right. And, you have to read the statute. I actually haven't read it in a long time because I feel like these late notice disclaimers are few and far between, to be honest, anymore. But they, basically it says that, if it's over 2 years from the notice, then the plaintiff bears the burden of proving it, or the insured bears the burden of proving that it wasn't late. Where if it's less than 2 years, then the carrier bears the burden of proving that they weren't prejudiced by the delay. So there's a bunch of different requirements in there, but that is the one area where if you had a late notice for some reason in your case, that a plaintiff might have a right to challenge the coverage piece, as opposed to just the insured.
And I posted the law in the chat for everyone. If you want to click on it, insurance law 3420, I think it's subdivision 6 that talks about the right for an injured party to bring an action if the disclaimer is based on the defendant's or the party's failure to give their carrier timely notice.
And then the only other thing I'm going to say, Matt, and then maybe we'll open up to more questions, is the prompt tenders of defense are something that needs to be a complete priority for the defense. And, it's the kind of thing where if there's any delay in these things, it just delays everything. The tenders should be issued early and often, is what I always say, and even if you don't have the contract, I mean, you don't want to tender off if it's not legitimate. They're probably going to deny the tender. But, I don't think it hurts to send a letter saying, we're trying to get copies of the contracts. We're placing you on notice, and letting them know that this is going to happen. If you never find a contract, they're not going to accept your tender. There's nothing you could do about that. But once you get the contract, and even once you get the contract, it's tough to have these tenders accepted. It depends on who the carrier is. Some of the carriers accept the tenders very quickly, and some of them don't. So these are some of the things that I look at. I look at the disclaimer. I look at how thorough the disclaimer was. Right? Is it, under the insurance law, it has to be very, very specific. Right? So is the timing right? was the language correct in the letter to the insured? Did they carbon copy the plaintiff and all the other claimants? So these are some of the things, that we look at. There's also reservations of rights. Sometimes the carriers reserve their rights, and rather than just a straight out disclaimer. And you have to be careful with those in your case, because that could impact you ultimately. Even though a lot of times people get these reservations and they just kind of toss them in the file. Reservations are worth reviewing and worth looking at what the basis of that reservation is, because it could impact, your recovery for your client. Does anybody else have any questions?
It's popping again. Sorry.
Hello. No, please do.
In a situation where, I guess, what is considered like a sufficient acceptance of the tender on the other side, right? So like if you have a situation where, well, let's say a carrier gives their attorney like permission to tell the co-defendant owner's attorney that we'll accept your tender, whatever, and then afterwards that attorney is saying, or their carrier is like, we want like a formal letter, like an acceptance letter outlining we formally accept it. But then there's an issue getting that letter sent to the owner's insurer and their counsel. Like, is that an issue? Sorry.
Oh, that's okay.
Is that an issue that is like basically the other side asking, we need this formal letter of acceptance before we transfer the file, accept it, etc. Is that like an accurate position to have, or is just a simple like we accept, like writing an email, we accept your tender? Yes, we accept your tender. Is that sufficient?
Well, not always. So the first thing I'm going to say is the tender typically is what triggers the duty to defend, and that means defense costs, right? So as a defendant, I remember that we would, or even when I represent a policyholder, when I tender, we tender, and then basically that's the trigger. So if they want to fool around and they're not going to respond to my tender, guess what? Defense costs are ticking in the background, right? And they know that. I mean, most carriers know that. But you do have to be careful what these tenders say, because you want to make sure that the tender is without a reservation of rights. You want to make sure that it's, a full acceptance of the tender. And a lot of times I have seen many times where the carrier, like the way they write these, or their counsel, whoever's writing it, the way that they write these acceptances of tender, it's not clear. Is this without reservation or is this with a reservation, right? If it's without a reservation, then technically, right, they can take over your defense and have one counsel representing both defendants. And there's a lot of there's a lot of issues with that, because you do have to be careful. If, let's just say you have a big case, right? In your case, you think the case is worth, whatever, $5 million or something like that, right? And now you're tendering, but you're tendering, they only have $1 million in coverage. So there's a problem there, because first of all, you're withdrawing. If they're going to accept the tender without a reservation of rights, you're going to withdraw your cross claims. They're going to ask you to withdraw your cross claims. And really, if they didn't get enough coverage, you really can't withdraw your cross claim. So there's a lot, and it would be difficult for me to get, I'd have to have an exact example of a tender or a response to a tender that you're talking about. But there are a lot of technical issues with tenders, with acceptances of tenders. And, you do have to be very careful and not just be like, okay, that's it, they accepted my tender and move on, because they need to specifically put in writing the basis of the acceptance. Is it without reservation? And then, if it is with a reservation, then you may be entitled to independent counsel. You may be able to stay on as counsel, in other words, and then they have to pay for your defense, for your client's defense. So there's a lot of technicalities with it. Anybody else have any questions?
Rosa, can you explain for some of us who are not as versed with the language, what a tender actually is, and what are sort of the requirements for a tender to be a legitimate or valid tender, and how that works?
And well, I'd be curious to hear from some of the other seasoned attorneys on this, because I've been asked this question and I don't know of any specific law or insurance law or case law for that matter that talks about what the specific requirements are for a proper tender. And all I know is that when I've done tenders, right, I want to, make sure everything you're identifying, obviously the case and the parties and what have you, and that you're basically, citing to the contract. I try to make it as thorough as possible because you want the carrier to take over the defense. You don't want them to deny it on a technicality, right? Or not even a technicality. If they don't have a contract, they're not going to accept your tender. So, I try to make it as thorough as possible, giving them a copy of the contract, saying we're an additional insured. Here's a certificate. If I have the policy, even better, that's even better if I have the insurance policy, and really specifically requesting defense and indemnification, right? So I had a client call me once and say to me, it was a carrier client, and say to me, the broker sent me a letter, sent me an email, a tender. And like, that's not a tender. That's not a tender. And they're arguing with me, it's not a tender. I'm like, yes, that is a tender. So, does anybody else have this experience where is there anything that I'm missing? Is there some specific law or regulation anybody knows that says what really is a tender? Yeah, I don't.
There you go. If
Right.
I guess it's not. So, but I have a follow-up question for that, Rosa. So you're tendering to another entity, in essence saying, all right, we need you to pick up the defense, the cost, the coverage, all of that. Do they have a certain time within which they must respond, or if they ignore you, what's the next step if you don't hear back from them?
Okay, so that's a great question, Andrew. So now the first thing I'm going to say, if you tender off to the sub, let's just say, right, and your tender doesn't have sufficient information for the carrier to really figure out whether or not they should accept the tender, right, that might not trigger the defense costs, because they're going to say, we didn't know. So, and until they have the information that they need, which in my opinion is really just, the contract, right? And you tender the defense, you have the contract, and you know that you're an additional insured, even a certificate of insurance. I think that's sufficient for a tender, but it depends on what the complaint alleges. You have to look at the allegations of the complaint. However, on the carrier side of things, they run the risk that if they don't disclaim coverage, let's just say, I'm going to give you an example, these employee exclusions, right? So somebody sends a tender, and let me lay this out for you. So you have plaintiff who sues owner and the GC, and then the GC brings in the employer, right? That's like the simplest example. So now the GC and the owner are going to tender off to the employer's carrier, right? Now that carrier has an employee exclusion in it. There is very few excuses they're going to have to be able to say that they didn't know that an employee of their insured was involved in this accident and that they should have disclaimed, right? So the tenders do that too. The tenders start the process of everybody having to respond. And if they're going to rely upon exclusions to coverage, they're going to have to disclaim in a timely manner. So that's why these tenders are so important. The fast tender and the fast response. And I think, a lot of my former clients who were the carriers, they were very attuned to this, and the turnaround time, needed to be very quick on these responses, because if there was a basis to disclaim coverage in that they needed to do it timely and quickly. So yes, and it's important. It's important that, but again, I had another case, which I'm remembering, where, you know, the carrier tenders, one carrier tenders to another carrier, but they don't have the contract, right? So now the carrier is going to say, we don't have the contract. We don't have sufficient information to respond to your tender, right? So their position was, until we got them the contract, there was no basis to deny the tender. We didn't have to, we didn't even accept the tender, I should say. There was no basis to accept it. We didn't have the contract. And I think that that's legitimate. Now, whether or not they needed to disclaim coverage, that's a different story. It depends on the facts of the case. You know, and I think any carrier would be, you know, smart to just disclaim, even if you weren't sure. You know, not say, oh, we don't have enough information. If you have some information and there's a possibility that there's going to be no coverage, then they need to do something, either send a reservation of rights or they need to send a disclaimer. And that's, you know, that's the course of action that they should be taking.
Great. Rosa, that's one of the reasons as plaintiffs' lawyers, we always send notice of the accident to every potential tortfeasor, because then we can always rely upon that. And if we find out who their carrier is, obviously, we're going to send something directly to them as well to try and get that clock started in case, so that we can perhaps get an argument of untimely disclaimer if they do ultimately disclaim.
Yeah, and you know, I find a lot of times, you know, I would caution just sending an email, just tender. I mean, I think, you know, you can do that but if they have a lawyer, that's one thing. But, you know, I would recommend sending it. You can send it by email. You can get emails for every carrier that there are, but sometimes you're just going to get this general mailbox and you don't even know where it's going. You know, I recommend in those situations where you don't exactly have the proper representative or contact, that you also send it, you know, certified mail. You know, and that way, you know, if you send it certified mail that, and I mean, that you're going to get a receipt back. You could send it regular mail as well, you know, first class. I mean, there's a presumption of receipt of first class mail, but I think it's harder to prove that you sent it. So those are the factors that you need to take into account. But I certainly recommend, you know, mailing it to, when you're just sending it to the carrier, mail it as well. Anybody else?
Yeah, we have 9 minutes left. So if anybody has any questions, now would be a great time to throw it out there. Otherwise, we can let Rosa just continue chatting for another 9 minutes. If anyone's too shy that you don't want to ask things in the public forum, again, for those of you who joined late, if you click on the chat, you should see the link to, if you scroll up, there's a link to have a consult with Rosa directly in a one-on-one Zoom. And also, you can scan the flow code in there, that circle with your camera from your phone, to get a lot more information as well. All right, Rosa. Oh, there we go. Peter turned on.
Hey. Yeah, sorry. I tuned in late. I wasn't sure if this question was answered already. What is considered an untimely disclaimer? Like, is there a statutory time frame that the carriers have to respond, or is it more of a facts and circumstances type of situation?
It's definitely a facts and circumstances. It's insurance law 3420, and it says, you know, as soon as reasonably possible, they have to disclaim, right? So what basically in you know, the way that I say it, layman's terms, is once they have sufficient facts to form the basis of the disclaimer, at that point, the timing is triggered, right? So what's timely? Everybody says 30 days. That number comes from case law, and that number comes from cases where the carrier didn't do anything. So they had no excuse. They had no excuse for that 30-day delay. But the carriers can have it. I was a carrier counsel for many years. As long as they're doing things and working their files and trying to figure out the answer to the question, whether it falls under the exclusion, they shouldn't be precluded. But like, for example, the ones that, the courts kind of say, no, you can't get away with this, is late notice. Like, the notice is late. So the carriers are very strict on that disclaimer. Same thing with if there's an employee exclusion. If it's your insured's employee, there's no excuse for not disclaiming coverage timely. So they just need to do it when they knew or should have known the particular facts. But that 30-day rule of thumb is what we all keep in mind as a rule of thumb. And when you see it kind of broaches that 30-day on either side, you're like, oh, it's getting close, and they may be able to challenge it. But that's the rule. It's not a set time frame. Yeah.
Okay.
Thank you.
Thanks, Peter.
No, thank you.
Good to see you.
Good to see you too.
All right, Rosa, you have a few minutes to wrap it up.
Yeah. Okay, so I just, the one of the things I do want to kind of end this with is, for those of you that have clients that you're handling, cases for, that are insureds, carriers obviously have a lot of resources. They have a lot of lawyers that they can talk to, and a lot of coverage lawyers that they can talk to, where sometimes the defendants don't. So I do recommend, especially if your clients have businesses, that, maybe you encourage them to have their policies reviewed so that, you first of all, it's your client. You want to make sure that they're not protected in that case. It's your client. This person could be a repeat client, could bring you additional business. And I find that is what has happened in many of my cases. It started off with a coverage litigation that some client got caught in. And then suddenly they thought, I'm never getting caught in this again. And they have me reviewing, their policies, their contracts, their leases, all those different things, so that we can review it and determine, are you protected, right? And then there's business decisions people have to make, right? I mean, I hear all the time, oh, they just want to save money. And that may be true. They didn't get the good coverage, right? But the coverage is hard to get. And I think we're all going to have a problem down the road, because a lot of carriers are pulling out. It's the labor law market and field is very, very difficult for the carriers. It's very expensive. The losses are huge. And the losses, in particular per clients, you have a concrete contractor, you have somebody who's doing demo. I mean, it is difficult for these people to get the correct insurance. And I think, these are issues that, we're all going to have to face in the future if they can't get coverage. They'll all just be out of business. So, but my point is, I do recommend that if you have clients that maybe suggest them, maybe you should have your policies looked at, by someone. I can't do it because maybe you represent the carrier, but just so that you're protected in the future, and that, you make sure that you have the proper coverage to cover you. But other than that, I'm going to leave it with, please feel free to reach out to me. And hopefully, if you wanted to send me some emails about additional topics, I know some people, threw some questions in the email that they sent in response to the forum, the roundtable, that weren't construction related. So I'd be happy to talk to you and answer those questions. And or to any of your colleagues if they have questions, or like I said, schedule a meeting, come into a Zoom with the firm, and I'll just talk to you on the one-on-one. So I want to thank everybody for joining us, and I hope that you got something out of today.
Yeah, thank you, Rosa.
Thank you.
Thanks everybody for joining us, and keep a lookout for further emails. We're definitely going to have some more roundtables, and we'll try and we got a lot of response. About 75 people responded that they were interested in these roundtables, which we are really pleased to see. So we may do one focus just for claims people, one maybe just for defense, one for plaintiff. We're going to sort of look at all the different people and where they're from, and try and drill down on it, and have some more of these roundtables that hopefully will produce value for everybody. So thanks for joining us. Reach out with any questions, and we look forward to seeing you at the next one.